Okay, so picture this. You're trying to get to Ireland's highest court, but it's like navigating a maze, a really complicated labyrinth. You've got to solve every puzzle, hit every deadline, and then, right at the end, you find yourself standing in front of a single, locked gate. Today, we're going to figure out how to find the keys to that gate.
So what does it actually take? That's the big question we're diving into. Because getting an appeal heard by the Irish Supreme Court, well, it isn't a right. It's a rare privilege. So how do you earn it? The answer is a story about a massive constitutional shift, some incredibly strict rules, and a whole new way of thinking about what a Supreme Court is for.
To even begin to understand this journey, you first have to understand the destination. And that's because the Irish Supreme Court today is a totally different beast than it was just over a decade ago, all thanks to one huge constitutional amendment.
Just look at this transformation. Before 2014, the Supreme Court was basically drowning. It was legally stuck hearing most appeals coming up from the High Court, and this created insane backlogs. We're talking years-long delays. The system was completely broken. The fix? It was the 33rd Amendment. This created a brand new court of appeal to handle the day-to-day work of correcting errors. And that freed up the Supreme Court to become what it is now, a court that only deals with issues of the absolute highest legal and constitutional principle. It totally changed the game.
So, you think your case has that kind of principle? That's great. But hold on. Before you can even argue that, you have to survive what lawyers call the procedural gauntlet. This is the labyrinth part, and you better believe it's designed to weed out anyone who isn't 100% on top of their game.
The pressure is on immediately. The second a lower court's order is perfected, which just means it's been formally signed and finalized, a stopwatch starts. You have just 21 days, 3 weeks, that's it, to get your initial notice of application filed. And then, from that original date, you have a mere 7 weeks total to put together and file this massive document called the Application for Leave Booklet. And these deadlines, they are razor sharp and totally unforgiving. If you miss one, your journey is probably over before it's even really started.
And that booklet, oh, it's a monster. The responsibility is completely on you, the applicant, to gather every single piece of paper. I mean, everything. The application itself, the order you're fighting, the written judgment that explains that order, and this is the real kicker, every single final order and judgment from all the lower courts throughout the entire history of the case. And for criminal cases, it's even worse. You need trial transcripts, exhibits, the whole shebang. The court is sending a very clear message here. We are not going to chase down documents for you. Your case has to be served up to us perfectly and completely on paper.
Okay, let's say you do it. You navigate the procedural labyrinth and survive. You've made it to the gate, but it's locked. To get through, you need one of two special constitutional keys. This is the real test. This is the heart of the whole thing.
The main key, the one that unlocks the gate most of the time, is proving your case involves a matter of general public importance, or GPI. Now, this isn't about whether the case is important to you. It's about whether the legal question you're asking is important to the public, to the law, to the country as a whole. Do its consequences ripple out way beyond just you and the other person in the case?
So what do they actually see as important? Well, it could be a completely new point of law that no court has ever ruled on. Or maybe you've got a situation where different lower courts are saying different things, and the Supreme Court needs to step in and be the tiebreaker. It could also be an issue that has a huge systemic effect on an entire industry, or even on how the justice system itself works. It's really about building the law, not just applying it.
Now, there is a second key, but it's much, much rarer. An appeal can be granted if it's in the interests of justice. You can think of this as a kind of constitutional safety valve. It's for those really exceptional cases that might not be important to the whole country, but where a really deep and specific injustice would happen if the highest court in the land didn't get involved. It's a very high bar, and they don't use it often.
You know, abstract tests are one thing, but let's see how this all plays out in the real world. We're going to look at two big cases. In one, the gate slammed shut. In the other, it swung right open. This is where you can really see the principle in action.
So here we have the case of BS versus the Director of Public Prosecutions. The DPP wanted to appeal a decision, and their whole argument was basically that the court below just got it wrong, that it misapplied the law. But the Supreme Court said no, and they made their new role perfectly clear with this quote.
Their job, they said, is no longer to be a court that just corrects errors. That's now the job of the Court of Appeal.
But now, look at this one. PricewaterhouseCoopers versus Quinn. This was a massive, incredibly complex business dispute. The issue they wanted to appeal seemed kind of technical. It was about how much detail you need to put in your legal claim. But the Supreme Court granted the appeal. Why? Because, as they put it, that one procedural question actually raised fundamental issues about fairness and how you manage cases that would affect every other large-scale case in Ireland. It was systemically important.
Putting these two cases side by side, it just makes everything click, doesn't it? The BSV DPP case was just an error correction appeal. The law was already clear, the argument was just about the specific facts. So, the gate closed. But PwC v. Quinn, that was about a systemic principle. The issue itself was going to affect the entire justice system. The gate opened. See the difference? The court is looking for cases that build the law, not just police it. So, after all that, the rules, the examples, what's the secret? What's the ultimate strategy? Well, it boils down to something that's more than just legal know-how. It's really an art. It's the art of persuasion. And here is it. This is the whole thing in a nutshell. The single most important skill. Winning here isn't about proving that you were right and a judge was wrong. It's about translation. You have to take your specific private problem and translate it into a big, important public question. A question so compelling that the highest court in the nation feels it has a duty to answer it for everyone.
And this whole system, which is designed for efficiency, designed to develop the law at the highest level, it leaves us with a really big, difficult question. If someone suffers real injustice, but their case doesn't happen to raise a new point of law or have that big systemic importance, who's left to fix it? That's the trade-off. And it's right at the very